In simpler terms, in the immigration process in the USA, a writ of mandamus is a remedy for visa applicants using which they can effectively address and resolve the unreasonable delay in their visa processing. For writ of mandamus and any lawful immigration-related services, contact the address and phone number shown on the screen. You can also mail at info@rajulaw.com. Rajulaw is your trustful address for any assistance and advice regarding immigration to America.
Hello everyone, and welcome back to the weekly live session held by attorney Raju Mahajan and Associates. For today's session, I am your host, Isabella Rosario, and with me I have Mr. Raju Mahajan himself. Mr. Mahajan, this is great to have you here today.
Yeah, thank you very much, Isabella, and I welcome everybody who are watching our show at this moment or will watch our show in future in our different social media platforms. So without further delay, let's start talking about our topic of discussion, which is writ of mandamus for asylum cases. I would like to start there. Can I see the PowerPoint? Yeah, thank you very much. As I said, so writ of mandamus is a special tool to resolve unreasonable delays. So a lot of time, I see that especially in recent times, in asylum cases, there's a lot of delay, especially even sometime I saw like 7 to 8 years, 9 years kind of delay in asylum cases, which is really, really unreasonable, and it should not be that long. So to address that issue, definitely we can use writ of mandamus to resolve this issue. Can I see the next topic? All right, so the first question is, what is a writ of mandamus? It is a lawsuit in a federal court to compel a USCIS office or another court to do their job within a reasonable time. So by the way, in our today's presentation, I will use the word reasonable delay a lot, and I'll definitely explain what is a reasonable delay, how long is a reasonable delay and everything, but you have to remember this word reasonable delay anytime you think of writ of mandamus. So bottom line, what writ of mandamus does is they compel any kind of government official. It doesn't have to be for immigration. It can be for any government matters. You are compelling a government officer to do their job in time. That is kind of like the very simplest term. Next slide, please. So the question is, when can you file writ of mandamus? So the short answer is anytime when there is an unreasonable delay, you can file writ of mandamus. So, in a asylum settings, whenever you submit your asylum application, the next step is getting fingerprint, like a biometric appointment. Sometimes you get it within 1 month or 2 months, which is good. Excuse me, which is good. So, however, sometimes it takes 1 year, 2 years, or even 3 years just to get a fingerprint appointment, which is extremely like unreasonable. I do not understand why they need like a 2-3 years just to get a fingerprint done, but sometimes it happens. In my opinion, probably they just forget about the case. They just put the case in a shelf and they just totally forget about that. So yes, if there is a delay in getting fingerprints, you can file writ of mandamus. After sorry, I forget to mention one thing here. So after the fingerprint, the next thing is application for work authorization, EAD card application. Usually you are eligible to apply for EAD card after 5 months of submitting your application. So after 5 months, let's say you applied for EAD card, which is I-765, it's a form. And usually you are supposed to get the EAD card approved within 1 or 2 months. Sometimes I saw that people do not get their EAD card, do not get their work authorization, even after 1 year of filing the application. So again, you can also file writ of mandamus to get your work authorization application approved. The next thing is interview. Whenever you submit a USCIS application, asylum application to USCIS, interview is the number one, the most important stage. If you do not get an interview within 1 year of submitting your application, you can definitely, file writ of mandamus to get the interview scheduled. And in our experience, this is the most commonly used step for writ of mandamus for asylum cases. So most of the writ of mandamus related to asylum application happens for getting an interview scheduled within a reasonable time. So again, let's say you already have your interview, and the interview officer usually tells you will get the result within 1 or 2 months. However, sometimes people do not get result within even 1 to 3 years. In that case, you can definitely file writ of mandamus to get your asylum interview result. Then in the result, USCIS officer may approve your case. If they approve your case, then that's good. You get the green card. If they do not approve your case, sometimes they will just say, sorry, we are not approving your case. We are denying your case. In that case, you can go to court, immigration court by yourself, and by yourself meaning with the help of attorney. Sometime USCIS officer will say, well, I cannot come to any conclusion, so I am submitting or transferring your case to a immigration court for further processing. So once USCIS transfer your case to an immigration court, sometime the court will schedule your master hearing within a reasonable time, sometime they will not. In my experience, I saw sometimes people do not get the first hearing, which is called master hearing, within 2 3 years. In that case, you can also file writ of mandamus to compel the immigration court to schedule a master hearing. So bottom line is, anytime when there is a delay, you are entitled to submit or file writ of mandamus. The question is how long you have to wait. I'll definitely discuss that in a minute, but you have to wait a certain period of time before you file writ of mandamus, because just because some agency or some office is delaying, let's say 1 month or 2 months, you cannot submit writ of mandamus. Your case will not be accepted by the court. Next slide, please. All right, so what is an unreasonable delay? As I said, in writ of mandamus question, this is the number one, this is the most important question. How long is an unreasonable delay? There is no right answer. There is no magic answer for this. It depends on the situation. It depends on the court. It depends on the application. So everything is up in the air in terms of defining unreasonable delay. On the top of that, different attorney may define it in a different way. Let's say today I'm telling you that after applying for asylum application, if you do not get your fingerprint done within 1 year, you can file writ of mandamus. And another attorney may say, well, no, not 12 months. I would say 18 months. Who is right? Me, I'm saying 12 months. Another attorney is saying 18 months. Well, both of us are right, because law works in that way. It is subject to interpretation. Every attorney will interpret his or her way, and the judge will decide who is right, who is wrong. And even one judge may say this is right, another judge may say this is wrong. So that is the beauty of law. There is no black and white answer. Everything is in the gray area. So reasonable delay, the way I define, let me tell you, for fingerprint, I would say you have to wait at least 1 year before you submit your asylum application. For work authorization, I would also say at least 1 year before you submit writ of mandamus to get work authorization done. For interview also, I would say at least 1 year, but if you want better result, I would say please wait 2 years, because there's a huge delay. Excuse me. There's a huge delay in asylum application processing. So I would say if you're waiting for more than 2 years to get an interview, then file writ of mandamus. That will be more beneficial to you. And then getting the court schedule, especially for master hearing, I would say another year to wait for before you submit writ of mandamus to get your master hearing scheduled. So usually for everything 1 year, for interview I would say 2 years. And again, this is also, it depends on many factors. Sometime I may say, no, 6 months is over, let's do it. Sometime I will say, well, even though 1 year is over, but let's wait a little bit, then we'll file writ of mandamus. So this unreasonable delay is very subjective, depending on many factors. So there is no black and white answer. Everything is gray. Next slide, please. All right. So before filing a mandamus, I would recommend you must exhaust all available options before you go for mandamus, because mandamus, number one, it is expensive. Like our firm is probably one of the less expensive firm in terms of writ of mandamus in the entire America. A lot of law firms, they charge like a $10,000, $12,000 just to file a mandamus lawsuit. We charge like $3,000. Not only is expensive, at the same time, according to law, writ of mandamus, like a mandamus lawsuits, are supposed to be the last resort. So you must exhaust all available options before even if you move for writ of mandamus. So the first thing is I would request you to request the office to expedite your case. So let's say your case is pending in a USCIS office. Call them or send them email. I understand that sometimes it's very hard to get them on the phone line, especially USCIS customer service. It's very hard to find a human, but they have a robot called 𝗦𝘂. You can ask about your case to 𝗦𝘂. 𝗦𝘂 sometimes give good information, sometimes she doesn't. But try your best to call them, email them, request them to expedite your case. If they cannot do it, the next option is ombudsman office. There's an office called immigration ombudsman. They can inquire about your case, and sometime based on their inquiry, your case may move forward fast. Sometime it may not happen. The next option is federal senator/congressman. So you have to find your local federal senator or congressman. I have to tell something here. There are two kinds of government in America. One is a federal government, one is a state government. Federal government has senators and congressmen. Very similarly, every state has their own senator and congressman. So please do not contact your state senators or congressmen. You should contact your local federal senator or congressman. And you can also contact both senator and congressman. Usually there's two senators in every state, so you can contact both senators, and usually there's one congressman in your district. You can contact all three of them. That's fine. There's no problem with that. So contact your federal senators or congressman. Sometimes it helps. Even after doing trying all these options, if your case do not move forward, then you file writ of mandamus. So writ of mandamus is the last resort when you have no other available options. Next slide, please. All right, so what is the steps of writ of mandamus? So first, we file a lawsuit to a U.S. district court. So again, there's two different court system here in America. One is a federal court system and one is a state court system. So no matter which state you live, let's say you live in Maryland, Maryland has its own state court system and also federal court system. So writ of mandamus lawsuits must be filed to the federal district court, not the state court. Then after submitting the case to the court, by the way, we usually take like 2 weeks to prepare your case and submit it to the court. The next step is receive summons from the court. Court usually take, I would say, 2 to 3 business days to issue the summon and send it back to us. Once we receive the summon, we print it and ship it to all the defendants. Usually there is 10 to 12 defendants in every writ of mandamus lawsuits. That's why there's also like a expensive like a shipping cost. We use FedEx. So let's say to submit summons to 10 defendants, probably there'll be like a $150 to $200 just to ship those documents. That's why I said mandamus lawsuits are expensive. Also, there's a court fee of $402. So once we send summons to the defendants, 𝗬𝘂 is Assistant U.S. Attorney. So the Assistant U.S. Attorney in that district, he or she will communicate with us, and there's a lot of back and forth communication before you get the results. Sometimes it takes 60 days, sometimes 90 days, sometimes it takes a little more than that to get results, but usually it happens within 60 to 90 days. And within this 60 to 90 days, there's a lot of communication back and forth between me means your attorney, and 𝗬𝘂. By the way, most of the communication between me and the 𝗬𝘂 are privileged. I'm not entitled to share those information to our clients. Previously, I tried to share some of the court information to my clients, and court specifically asked me not to share those information to you because all these communications are privileged. So yes, my communication with 𝗬𝘂, my communication with the client, definitely I'm representing you. I'm doing everything for the best outcome for you, but I'll not be entitled to share all the information with you. Next slide, please. All right, few things to know before we end our discussion today. Number one, purpose of mandamus is not to approve your case. A lot of time when people come to us and they try to file mandamus, they say, oh, you must get my case approved through this mandamus. Well, that is not the purpose of this case. The purpose of mandamus is to get your case move forward faster. The purpose of mandamus is to compel the officer who is working on your case within a reasonable time. So when it moves forward, your case may get denied. However, in most of the cases, like according to our experience, in more than 99% case, your case may get approved. So, which is a good thing for you. That's why we file mandamus lawsuits. But it is not like automatically getting approved. In a worst case scenario, your case may get denied fast. That is also an outcome of mandamus. So you have to know this thing. And when we get a result, either a positive or negative, within a reasonable time, that is the positive outcome of mandamus. So I hope you understand this scenario. The second thing is there is no fixed course of action. As I said, law is subject to interpretation. Every case is different. Every judge is different. Every law clerk is different. Everybody process their case in their own way, in a unique way. So a lot of time our clients say, well, my friend filed a mandamus lawsuit with another law firm and it went this way. Why it is in my case, it is going in a different way? Well, every case is different. Every court is different. So that's why I said there is no fixed course of action. Me as your attorney, I take decision based on the circumstance, based on the situation. Every case is different. It will move forward in a different way. I mean, it may move forward in the same way. That is possible too. But in general, every course of action is different. The last thing you should know before we conclude our discussion is you will not understand all activity. So, mandamus lawsuit, any court procedure, it's a complex procedure. Let me tell you just one thing. So whether I should file your case to Federal District Court of Washington, D.C. or Federal District Court of Maryland, this simple calculation is a complex legal calculation called venue shopping. So, venue shopping is a big topic. In the law school, we studied 3 weeks. It's called forum shopping or venue shopping. So I'm not going to, explain the entire venue shopping or forum shopping things with you. I will make the judgment whether I am supposed to submit your case to DC or Maryland. And I'll just tell you, please trust me, I'm doing the best for you. So similarly, there is a lot of action that we as attorney, we take to getting your case approved for the best outcome for you, but you will not understand everything. And this is what it is. This is the system. So you have to trust your attorney. No matter you retain our service or service from another law firm, I advise you to trust your attorney. If you do not trust your attorney, please do not take that service, because at the end of the day, it's very hard for attorney to explain everything to you. At the same time, it is very hard for you to understand everything by yourself. So trust your attorney, let your attorney do whatever best for you, and depend on that. So that was our short discussion about writ of mandamus for asylum cases. Next slide, please. Yeah, this is the thank you. Yeah, so I hope you get a lot of information out of here. If you have any other question or any query, feel free to reach out to us. We'll try our best to help you.
Thank you so much, Mr. Mahajan, for that informative presentation. Thank you so much to the audience members as well. If you have any questions, now is the time to drop your questions at our comment boxes. We have already had 2 people comment out their questions. The first question comes from Mr. 𝗟𝗶𝘆, and he asks, if I convert from B2 to F1, then can I return to the country, or after I change F1 status, will I be receiving the sticker visa?
Thank you. Yeah, it's a very good question, a very common question. Anytime you do any change of status from within America, you are not going to get a visa stamp, because no office within America has authority to put a stamp in your passport. Only US embassies and consulates in foreign country are allowed to do that. Meaning, let's say you came to America with a B1, a B2 visa, and then within America, you changed your status from B1, B2 to F1. So once your application is done, once your change of status process is done, you have a valid stay here in America under F1 visa. However, if you go back to your home country or any country in the world outside of America, once you try to come back, you must have a visa stamp under F1 visa in your passport. So you will not get the visa stamp from America. That's why when people ask me this question, I say, do you have any plan to visit your home country within a very short time? If yes, I advise you to go back to your home country, apply for change of status in embassy, get the visa stamp done, and then come back to America. That will save some time. However, if you do not have plan to visit your home country within, let's say, 6 months or 1 year, then yes, you can change of your status from America within America, and that would be faster because once you submit your application to USCIS for change of status, there is a premium processing, and usually they complete the process within 2 to 3 weeks. It's very fast. However, if you go through the embassy route, consular processing route, sometimes it takes 6 months to 1 year. It's a very time consuming path. So bottom line, short answer to your question, you will not get the visa stamp if you change of your status from within America. And also, if you have planned to visit your home country soon, please go back to your country, get your F1 visa stamp, and then come back. But if you do not have plan to go back to your home country soon, then you can do it here. It will be faster.
I hope that answers your question, Mr. Rahman. We have another question from Mr. Bablu, and he asks, what is the EB4 visa? What is the requirement for this visa?
So EB4 has a lot of different kind of visas under one umbrella. This is a little confusing, I understand, and a lot of people ask me this question. So EB4 has many different, very different kind of visa applications in their term called EB4. But in general, most of the time, people refer to religious green card application, meaning if you are a worker in the religious context, meaning like let's say you are a pastor or minister of a church, you are an imam, a muazzin of a mosque, if you are a officer of a temple, if you are like a purohit of a temple, then yes, you can apply for green card under EB4 visa. So if you are talking about that, I can talk a little more about that. But again, EB4 has a lot of different kind of applications within their umbrella.
I hope that answers your question, Mr. Bablu. Mr. Rahman says, thank you for your clarification. You are welcome. We have some more questions today from our archive emails. So the first question is from somebody named 𝗦𝘂𝗍𝘆, and he asks, how can I obtain a U or T visa if I'm a victim of crime or human trafficking in the USA?
So the first thing is you have to report that crime to the authorities. So in general, when there is any kind of crime happens, if you're a victim, you should call 911. 911 is the phone tip line for your local police department. You have to report them, and as soon as you call them, they will go to your place, like the place of the crime, or you go to your residence and take a statement. After you give them the statement, get a copy of your statement, your police report copy. Also, if there is any need for medical treatment, go to a hospital or doctor's office, get the treatment done, and also get a copy of your doctor's note and like a medical treatment record. Once you have these two documents, at least these two documents, number one, a police report, number two, a medical report, then you can contact the immigration attorney. They will file for a U visa. T visa is for human trafficking. If you are a victim of a human trafficking, then you should immediately call your local police department by calling 911, and similarly get a police report. If there is any need for medical treatment, go to a doctor's office and get the documents, and then contact a immigration attorney. They will process. So as I said, there is no fixed rule for all the victims for all the crimes. It depends on the scenario, but yeah, those are the two kind of very mandatory things: one police report, one medical report.
I hope that answers your question, Mr. Ridoy. We have had some more questions in our comments. So Mr. Raj Sigdal asks, I have TPS and I'm also an F1 student. If I get advanced parole and go back to my home country and come to the US, will I be admitted as parolee or F1 student? My visa stamp is already expired. Thank you.
It depends. It depends on your parole document, and it depends on your F1 status. But in general, the short answer is parole. If you go to your home country with the advanced parole, then you'll probably enter the America as a parolee. But if your F1 status is still active, and if you meet all the requirements, so either can be possible. But in general, you will be admitted to America as a parolee.
I hope that answers your question, Mr. Sigdal. Mr. Rahman has another follow-up question, which is, if I have F1 visa, can I apply for asylum after 2-3 years?
Yes. So to apply for asylum, it is recommended that you apply within 1 year. 1 year of entering America. However, you can apply even after 1 year of entering America, but you have to give them an excuse, give them a reason why you did not apply within first year. So short answer to your question, yes, you can apply after 2-3 years, but you have to give a reason why you did not apply in the first year. And in general, the very common answer to this reason is situation has been changed. When you first came to America, the reason you are applying for asylum was not present. So the situation has been changed. Now you are scared of going back to your home country, or something else happened. So bottom line is, yes, you can apply after 2-3 years, but you have to show a reason why you did not apply in the first time.
I hope that answers your question, Mr. Rahman. We have another question from Mr. Imdad Khan, and he asks, hello, if I got F1 visa with a university and then after entering the US, I transferred to B university, suppose I need to come to Bangladesh, then again while entering USA, may I face deportation?
Well, deportation is very different thing. Like if you follow all the requirements, you can come to America with A university, and after coming to America, you can definitely transfer your service to B university. And if you follow all the legal requirements, then there is no problem with that. A lot of people, they transfer university from A to B, or even they do multiple times within like 2 years of study or something. If you follow all the rules and regulations, then there is no fear of getting deported. However, if you do not follow all the requirements, then yes, there is a chance. And if you ask me questions, so how do I follow all the requirements? So the first person you should contact before applying for any transfer is your DSO, designated school official of your first university. Every university is unique. Every university has their own requirement, especially if it is a private for-profit university. It has their own requirements. I strongly advise you to contact your DSO, express your intent of transferring your service to a different university, and then also contact the new university where you are getting your service transferred. If you meet all the requirements of these two university, then there should not be any fear of deportation. You should be good.
I hope that answers your queries. Then we have another question from our archive. So Mr. Fazlur Rahman asks, I have a B1, B2 visa and will soon marry a US citizen in the US. After our marriage, when can my wife apply for my green card? And what's the typical processing time for obtaining a green card?
So you can, I mean, your spouse can apply for you within after 90 days of entering in America with a non-immigrant visa like B1, B2 visa. Meaning, if you enter America today, your spouse can apply after 90 days of today to apply for a green card application. Now, there's a lot of question about this. Is your spouse is a U.S. citizen or a permanent resident? If the spouse is a U.S. citizen, he or she can apply for you. There's a 2 steps for marriage-based green card application. The first one is called I-130, and the second one is called I-485. So whether your spouse will be applied both together, depending on she is a U.S. citizen or not. If a U.S. citizen, they can apply both steps together. If that person is a permanent resident, then whether he or she will be able to apply both steps together, that depends on the visa bulletin. You have to check your category in the visa bulletin. If it is current, then yes, they can apply together. But if it is not current, then first he or she must apply I-130, getting it approved, and based on your priority date and based on whether it is available in the visa bulletin or not, then he or she will be able to apply for the second part. So it depends on many factors, but short answer to your question, he or she will be able to apply for you after 90 days of you entering America, and it depending on he or she is a US citizen or not, and it depending on the visa bulletin.
I hope that answers your query, Mr. Rahman. We have another question from Mr. Fazlur Rahman himself. So the second question he's asking is, I currently live in Bahrain with a residence permit. If I marry in the USA, then do I need to wait in Bahrain for green card approval, or can I stay legally in the US with my wife until my green card is approved?
No. So again, whether your spouse, he or she is a U.S. citizen or not, that depends a lot about this scenario. Since you are living in Bahrain, your spouse, no matter citizen or permanent resident, will apply I-130. Once the I-130 is approved, then it will move to NVC. In this case, there will be no I-485 because you are living in a foreign country. It will go through the consular process. And then in the consular process, you will face a visa interview. Once you get the visa, then you can come to America. You cannot automatically come to America just because your spouse applied for I-130. So If you are within America, there's a one kind of calculation. If you're outside of America, there's a different kind of calculation for marriage-based application. So the short answer to your question, no, you have to stay in Bahrain until you get immigrant visa to come to America.
I hope that answers your query. Mr. Rahman has another question. He's asking, who already converted in F1 from B2, can he apply for his spouse or children by F2?
Yes, as soon as your F1 application has been approved, like change of your status from B1, B2 to F1 is approved, you are eligible to apply F2 application for your spouse and children under the age of 21. You are eligible to do that. You can do it immediately.
Thank you so much, Mr. Mahajan. We have some more questions from our archive. The third question comes from the archive by Shumon Rashid, and he asks, if I hold an E2 visa status within the USA, can I simultaneously apply for the EB3 visa? My second question is, alternatively, is it only possible for my dependent, my wife, to apply for the EB3 visa while I maintain my E2 visa?
Yes, answer to both of your question is yes. While you are in America with a valid E2 visa, you can apply for EB5 parallelly simultaneously with your E2 visa, or your spouse can apply for EB3 and you can be dependent later. Both of those are possible. Just remember one thing, you have to maintain your valid E2 status until your EB3 process is complete. So a lot of people, they just apply for EB3, like the first part, like a labor certification, and they quit their previous status, which is like either E2 or other kind of things, which will lead you to become undocumented. Please don't do that. Maintain your status until you get the green card. But yeah, in either situation, you can do it.
We have another question from Mr. MD Arafat Mahbub, and he asks, currently I hold an F1 visa for my MBA program at a university within the USA. I intend to switch both my program and university. Is it possible to facilitate this change through your firm?
Short answer is yes, but we have to go through your school DSO too. So you can do it yourself. You can contact your school DSO and say, hey, I'm going to transfer my school from you to another university and also transfer my program. So they will help you. But if you are shy about asking this thing, or if you have any difficulty communicating with them, yes, we have a student admission team and they can help you.
Thank you so much, Mr. Mahajan, and thank you all the audience members. Those are all the questions we have for today, and we look forward to seeing you next week at the same time as well. Hopefully, we will bring more in. Yes, Mr. Mahajan, yes. I'm sorry, I forgot about the news update. Mr. Mahajan, please tell me the news update.
Yeah, thank you so much. No problem. Yeah, so there are some updates about Visa Bulletin. Like recently there is a backlog, especially those who applied for NIW and EB3. They always check the Visa Bulletin, and you're supposed to check it every month. So recently there is a good news in Visa Bulletin. So currently the final action date for EB2 categories are December 2022, and date for filing is, I believe, July 2022. So they have been moved like 3 months, which is good. It's a good news. So I advise everybody to follow Visa Bulletin, and if you do not know how to follow Visa Bulletin, then I advise you to watch some YouTube videos. I have a couple YouTube videos about Visa Bulletin, and also other law firms, other attorneys have. So yes, know how to read Visa Bulletin and follow it regularly. So recently there is a 3-month progress in the Visa Bulletin. Second news is, so you already know that USCIS issued a reminder that August 1, 2023 version of Form I-9 is now available for use and contains changes to the forms and instructions. So this I-9 form is used by corporations to be e-verified to apply for any kind of immigration benefits. Let's say your company is applying for you for H-1B, EB2, EB3, or any kind of immigration benefit. The company must be e-verified with USCIS. And to do that, there's a form called I-9, and there's a recent changes in the I-9. So if your company is applying for you, ask them to use the latest I-9 form. Another good news is adjustment of status filing date. So USCIS determines that for September 2023, applicants in all family-sponsored preference categories must use the date for filing chart, and applicants in all employment-based preference categories must use the final action date chart. So this is another thing about Visa Bulletin. As I said, Visa Bulletin sometimes could be a little complex to understand. So not only there is 2 charts for each categories, One is called date for filing, another one is final action date. Not only that, USCIS will tell you which chart to follow. So let's say right now USCIS is saying for the month of September, all family sponsored preference categories must use the dates for filing chart, and applicants in all employment based preference categories must use the final action date chart. Not only there's two charts, USCIS will tell you which chart to follow in which month. Also, there is a good news in asylum application. So USCIS releases an affirmative asylum procedure manual due to a FOIA lawsuit brought by the Lewis Trauma Center. So there is a new procedural asylum procedure manuals, meaning there are some changes. There are some changes in asylum procedures. So I advise everybody who already applied for asylum or who is going to apply for asylum, please check this new asylum procedure manual. Its short form is AAPM. And again, it can be a little confusing for you to understand. In that case, contact your attorney and say, hey, what is the new changes in the new asylum procedure manual? I like to know it because it may impact my case. So that was our news update for today.
Thank you so much, Mr. Mahajan, and thank you to everyone who has been sticking till the end. We will see you at the same time tomorrow, next week as well. This has been Isabella. Thank you and have a great week.
In simpler terms, in the immigration process in the USA, a writ of mandamus is a remedy for visa applicants using which they can effectively address and resolve the unreasonable delay in their visa processing. For a writ of mandamus and any lawful immigration-related services, contact the address and phone number shown on the screen. You can also mail at info@rajulaw.com. Raju Law is your trustful address for any assistance and advice regarding immigration to America.